Join us at Prophet.me. The tradition of law traces back to medicine. When a physician, a medical scientist, like Josiah Bartlett, who is the governor of New Hampshire, who signed the Declaration of Independence for New Hampshire, was a physician. In his era, if he was going to hear a case, he was going to hear a case medically. That was the work of a physician, was to hear a case. He was functionally a judge. And that tradition of judging traces back to natural law. It traces back to law of knights and kings. And we're going to bring that back because that system worked so well. Having a legal system built on natural law was far more successful. Having Josiah Bartlett, a physician, Benjamin Franklin, a medical scientist, making decisions medically, based on medical science, based on medical law, based on natural law, rather than making decisions based on reading law. Reading law happens to not have an ancient tradition. When you read back to important cases adjudicated, you can look to a benchmark example of Nicholas Copernicus, where Copernicus was a priestly lawyer. He had a role within his church, but was a natural lawyer. He was a natural lawyer in a jagfetic place, which was like the Polish-Lithuanian Commonwealth, would be a kind description of it. Others might describe it as Prussian. Regardless, those people happen to have known that there was, heliocentric solar system where the Earth traveled around the sun, which was different than what his occupation held. So the natural lawyer took a case, in the example of Copernicus, to overturn canon law, which was priestly law, which was his occupation, which he did at some risk and at great risk. But people are enamored with the idea of natural law as law. And so we're going to bring that back here at Prophet.me and practicing natural law through magistrate law. And that's something that can be adjudicated early on in engagement with patients. Join us at Prophet.me and learn more.